So Fred, tell me, what is elder law?
Elder law is kind of a really an area of law that a lot of people hear the term, but they really don't know what it means, or they think it means elderly. And I don't need to get involved in elder law until I'm elderly. And that's as far from the truth as it is, because elder law consists of preparing for the aging process. Every single one of us are aging as we go, and things come about during that aging process. We deal with things like disability, accidents, injuries, incapacitation, and of course, ultimately death. And so the elder law arena is the law that covers all of those issues that come up as we go through that aging time.
Okay. So, I am in senior living and we talk with a lot of families on a pretty regular basis that typically are coming to us in a crisis. Very few come way ahead of time and plan for it. It's usually once something has happened. Typically, they're looking for their parent, a place to live and a solution. So, we find a lot of times they don't have proper documentation, they don't have proper information that they need to make those decisions for your parents. So that's why I really wanted to kind of talk to you today to kind of address some of those issues. So, where would you have a family if they want to pre-plan and not get caught in a crisis? What would your first steps be?
I mean, the easiest way to understand it, in my opinion, is you need to plan before you need it.
Mm-hmm.
And all of us think, and we live in the world of it's not going to happen to me,
Right.
or I've got plenty of time, I can take care of this tomorrow. And we are horrible procrastinators as human beings. And so I see it all the time also. And it breaks my heart when clients call us and say, we just had to put mom into a memory care unit. I need to bring her in to do a power of attorney. And I have to tell them it's too late.
Okay.
Mom can't do a power of attorney because mom has to understand what she's signing when she signs it. So the planning process needs to start before it's ever needed. And people say, well, how early should I start? It's never too early. I do planning for 18-year-old kids because the minute a person turns 18, they're an adult. And now they have to take care of themselves. And a lot of parents don't understand that. So we always suggest planning should be a constant part of your life from the time you become an adult at 18 all the way through the process.
Okay. So let me ask you, what are give me some of the documentations that people need to have ready, specifically as it pertains to taking care of an adult parent, and or planning for themselves. Like, and if you're in your 50s, late 40s, and you're thinking, I need to have a plan and enforce. So what would you suggest be the first things that you would want every person to have ready to go?
Well, I always look at a lot of the documentation that we do in two categories. We have living documents and we have death documents.
Okay.
And a lot of people really focus on that death document. I need a will. Or I may need a trust. But we don't focus on the living documents. And the living documents are the documents every person needs so that somebody can take care of them if they can't take care of themselves. And those are the documents that allow somebody I trust, maybe my spouse, my brother, my sister, my parent. I give somebody else permission to make financial decisions for me and healthcare decisions for me. And again, those kick in when I can't make them myself. And so that's where the problem comes in, is people don't think about that until they can't do it.
Mm-hmm.
And now all of a sudden, wait a minute, we've got an issue with mom. Mom is going downhill health-wise. We need to look at nursing care or whatever the case may be. And mom can't pay her own bills because she's not thinking right. Now we need to get something from mom. Well, that's when it's too late. You need to have these documents in place beforehand so that when somebody goes downhill, you already have the authority to write checks to pay the bills. You already have authority to talk to doctors about healthcare decisions, those kind of things.
Okay. So what documents would you recommend that every person has?
In every package that we do, and we do planning from the simplest to ultra complex. We have clients in the gamut. And everybody, no matter who they are, gets power of attorney, medical power of attorney, medical directive, HIPAA forms, declaration of guardian, designation of representative to carry out the remains, and an anatomical gift form for people that want to donate their organs upon death for transplantation. But those are the documents that every person needs during life.
Mm-hmm.
And another thing I see often with those documents is people don't realize that those documents live with you and they die with you. They're only good during life. They don't go beyond life. I get that call all the time. A big misconception on a power of attorney is dad passed away and now I need to pay some of dad's bills, but I have dad's power of attorney, so I'll use it at the bank to pay his bills. And I have to tell people, you can't. Once dad passes away, his power of attorney passes away, and you no longer have that authority anymore. They're only good during life to take care of financial decisions. Healthcare the same way.
So what would they need in addition to that? If they have during life, then what would they need if someone does pass?
So again, you need your living documents and your death documents. And when somebody passes away, then you convert from the living documents to whatever they have in death, whether that be a will, whether that be a trust, whether that be nothing at all. And unfortunately, a lot of people, I think the last figures I saw, over 70% of the population doesn't have documents in place. And so 70% of the clients we deal with are passing away with no documents in place at all. And what does that mean? That means the government rules. And I always tell people, if you don't have a will, the government has a will for you, and you're not going to like it. So whatever is in place at the time of death is what we look at. And typically it's a will or somebody that passes away without a will. The smartest thing is always a trust, and trusts are the greatest things ever invented, and they make the life of the family so much easier upon passing.
So let's talk a little bit about a trust then. Can you explain what a trust is?
A trust, the simplest way I think to understand a trust, and a lot of people are afraid of that term, or they've heard the term trust and they think, well, it's for the wealthy or it's for people with special circumstances, but I don't need a trust. And every family that I deal with could benefit from a trust, because what a trust does is it's just a different way of holding your property, and it's a different way of putting your wishes in place that does two things that my clients love. I've never had one client say they didn't want this. It keeps the government out of your life, and it keeps the courts out of your life, because you're putting a document together for your family that says, this is what I want done if I become incapacitated. This is what I want done if I pass away. You can even say, this is what I want done after I pass away when my spouse passes away. So it can go beyond death even. And the government has said, if you have a properly drafted trust in place, that trust wins, and it overpowers any law that's been written, and the trust governs how things are done. So, for instance, one of the things we see a lot is a power of attorney is the most difficult document there is, because the power of attorney is a document used to take care of finances. And a lot of people think a power of attorney is a power of attorney is a power of attorney. I can get online, I can fill out a power of attorney, I'm good to go. That's as far from the truth as you can get, because a power of attorney is really only as good as the people you give it to. And so if I go to Bank of America, or I go to Chase, or I go to Fidelity, or I go to any other financial institution, and I give them a power of attorney, they're going to analyze that power of attorney to make sure it meets their rules. And if it doesn't, it's as if you didn't even have it. And so our power of attorneys are very, very complex because of that. But if the power of attorney doesn't work, and it might not work when the person who signed it all of a sudden decides they don't want to honor it, because the living documents, a lot of people don't understand. If I have dad's power of attorney, dad has given me permission to take care of his finances. Dad can take that permission away. And he can take that permission away verbally. He doesn't have to sign another document. He can basically tell people, do not honor that, do not talk to my son, do not let him touch my money. And all of a sudden that power of attorney is no good. And even if dad's not thinking right because of dementia, Alzheimer's, whatever the case may be, the financial institution will honor dad's wishes no matter what. A trust can be written that says, I give my wife or somebody permission to take care of me even if I don't cooperate. So if I get dementia, if I get Alzheimer's, and I'm not thinking straight, and there's medical documentation to show that I'm not right, the trust says my wife or whoever I've appointed can still take care of my finances, still take care of me, even if I don't cooperate. So one of the great things about the trust is a trust can help avoid guardianship. And guardianship in Texas is where an adult becomes incapacitated and another adult has to step in and become their legal guardian to make decisions for them. A trust can help avoid that. A trust can also help avoid probate when somebody passes away. Another huge misconception I see all the time is people think, well, I have a will, so when I die, my spouse will take the will and do what it says, and they don't have to go to court. It's not true. All wills have, if they have anything to do with property or setting up a guardianship for a minor child or anything like that, they have to go through the court system. And so 90% of wills that we have to be probated, meaning you have to hire an attorney, you have to file it with the court, you have to wait on the court, and all that time period you're waiting, you can't do anything. A trust avoids that because a trust doesn't have to go through the courts. It operates outside of the court system. So when I pass away, if everything I have is in my trust, my wife doesn't have to do anything but get on with life and administer the trust. She doesn't have to go to court and do all that stuff. So a trust can, I think the big thing about a trust is a trust privatizes your life. It can give you benefits you can't get anywhere else, and it keeps the government and the courts out of your life.
So when you were talking about the power of attorney, so that's the same for medical, financial, or durable power of attorney?
Yeah, a durable power of attorney, a general power of attorney, a financial power of attorney, those are different names for the same document.
Okay.
It's a document that they really go into two categories. There's documents for finances and there's documents for healthcare. And so you have a financial power of attorney and then you have a healthcare power of attorney.
Okay. So let's say that I see this a lot. People come in and they say, I have dad's power of attorney. I want to go ahead and pick out a room for him, and dad's maybe at the very beginning of some light dementia, or maybe just has health issues and they don't want him to stay at home any longer. So those powers of attorney, they could not exercise that to force him to go into senior living.
No, they cannot so again, the powers of attorney are I giveth, I can take it away.
Okay.
I give you permission to take care of me, but I can take that permission away at any time. And so if there's a conflict between the power of attorney and the person using the power of attorney, which is called the agent, the agent under power of attorney, and the person that signed it, the person that signed it wins.
So let me ask one more question along that lines for clarification. With the trust, if the person is just being stubborn and doesn't want to move out of their home, but medically they really probably cannot take care of themselves anymore, the trust then would enable the family to go ahead and still require that person to do it if they can prove that they cannot do ADLs, or what would the stipulations be on that if they're sound of mind but they just are not willing to leave their home even though they can't care for themselves?
That's the key point, is are they sound of mind or are they not sound of mind?
Mm-hmm.
The trust is a contract. It's only as, and that's another thing I see a lot with people, that they price shop for these documents.
Mm-hmm.
The documents are only as good as how well they're written.
Correct.
And so a trust has to be written well enough where I have said when I was in sound mind what I want done. And therefore, if I'm not in sound mind anymore, the trust has dictated what I've already said. The problem comes in, though, is whether I am or am not of sound mind. And that's where I often have to tell people, whether you have a trust, whether you have a power of attorney, whatever you have, there's that fine gray area between mom or dad being perfectly fine and mom and dad being completely mentally incapacitated. When they're in between, now we're having problems.
Okay.
Because there's no way I can fix it or anybody else can fix that time period. I have to tell my clients quite often, I can protect mom if she's making irrational decisions because she doesn't know what she's making. I can't protect mom if she's making irrational decisions and she knows she's making irrational decisions. And so that's a real hard area in this elder law arena that we deal with. But a properly drafted trust will say, once there is documentation, medical documentation that says I am incapacitated, I'm not making sound decisions anymore, then the document controls what happens next. And if the document says that I give my children permission to put me in a nursing home or do things with me to be able to take care of me, then that document governs.
Okay, great. So I think a couple of the other things that we come across are, you have people that they did their due diligence when they were younger, and they maybe 20, 30 years ago, they wrote a will or they did things and they think, oh, well, I don't really want to change anything at this point. But yet they really haven't reviewed it in a while. And then let's talk about that a little. How should you review your will after a certain amount of time and just make sure you have exactly the way you want it, or what would you recommend for that?
All of these documents, we recommend our clients review them every 3 to 5 years.
Okay.
Because the one constant in life is change.
Mm-hmm.
And your life changes, your finances change, your family dynamics change, the laws change. Well, and in addition to the law changes that a lot of people don't understand from our side of the fence is legal strategies change and rules change. We make an average of 20 to 30 updates to our documents every single year. So if you're looking at 3 to 5 years down the road, we've already made 60, 80, 100 changes to our documents over that time period. Now, some of them are small, some of them are minor, but when you add them up, they become big. And so we always want to make sure we maintain that to keep it up to date. And what I mean by rule changes, a lot of people don't understand that there's a real big difference between the law and the rules. And the law may say that a power of attorney only has to have A, B, and C in it. But the rules from the financial institution may require it to have A, B, C, D, E, F, and G. And if the financial institution has different rules and your document doesn't have what meets their rules, then they won't accept it.
That they don't have to comply.
And they don't have to comply, that's right. So you want your documents more comprehensive than you think they're needed because of that. I had a situation one time where a family member called me. I had done mom's documents about 7 years earlier. And she says, I'm trying to deal with the financial institution and they're telling me that they will not accept a power of attorney older than 5 years old. And I said, okay. She says, does that mean mom's document is no good anymore? And I said, no, ma'am, it doesn't, because these documents don't expire. They don't ever expire. They're good forever. But I said, they're not good to this financial institution because they have a rule that says they won't accept one over 5 years old. Well, we had a real dilemma because mom had Alzheimer's at this point, could not do a new one. So we had to deal with the financial institution. Luckily, in that situation, I was able to get the financial institution to accept the older power of attorney, but they didn't have to. And if they didn't, it would cause major problems. So again, every 3 to 5 years, you should have your documents reviewed and possibly updated.
So one of the other things that we find, Fred, is that we have mixed families. We have the elderly even coming in now that have been divorced and had or remarried maybe twice, once, twice. And so they have my kids, your kids, our kids, or maybe they don't have any together, but they have mine and yours. Talk about some of the complications of people preparing when you're in a second or third marriage and when you have separate children and also children together possibly. What are some of the things that people need to be thinking about then?
Blended families are, in my opinion, need planning more than anybody else because there's so many laws against blended families. Mm-hmm. And when I give my seminars, I kind of explain the laws are state to state to state. So one of the things we haven't covered, but I want to just emphasize, you have to have documents from the state you live in because Texas is different than New Mexico, is different than Michigan, is different than Massachusetts.
Let me clarify for one second. The state that the parent lives in, or the state that the children live in, or what are we talking about?
Whoever's doing the document.
Okay.
So if it's the parent's documents, we want documents from the parent state. Okay. My uncle lived in Wisconsin, and he got diagnosed with cancer about 5 years ago. I went and saw him during the visit. Of course, I asked him, do you have your documents? Of course, he didn't. So he says, can you do them? I said, no, I'm not a Wisconsin attorney, but I'll get you a Wisconsin attorney. The Wisconsin attorney did his documents out of courtesy, sent them to me to review. I didn't even know what I was looking at because Wisconsin documents were so different than Texas documents that I had to trust that attorney knew what he was doing. Same thing with Texas. You have to have documents within the state that you live in, and you want to make sure those documents are comprehensive enough to be able to cover any situation that you might be involved in.
Okay. So, what if this happens quite frequently as well? The parent was in Wisconsin, but they've moved them to Texas. Is the Wisconsin documentation still legal after the amount of citizenship here, residency here in Texas, or do you have to redraw all the documents?
It's always a good idea to redraw your documents. And again, there's a difference between legal. Every document is legal.
Mm-hmm.
So if you bring, and we see this a lot around here, California, you bring documents from California, those documents are legal, but I can guarantee you're gonna have problems with them in Texas, because Texas people aren't used to seeing California documents, and they're quite often resistant to accepting them. So it's always a great idea, as soon as possible after you move to a different state, that you do documents from that state.
If you're going to continue residency.
That's
Is
right,
there
if
a
you're
time
gonna
limit on
maintain.
the residencies?
No,
Okay, so once you move, if you know you're going to be staying there, you probably need to have that.
yes.
So what happens, again, if they do have dementia at that point, then you pretty much have to just go by what you have?
Yes.
Okay.
Yes, we quite often just live with what we got, and then if we come across problems, then we look at the next step, which is guardianship.
Right.
And sometimes we have to go to that next step.
And I understand probate and guardianship are long, expensive processes, correct?
Very, very. Guardianship especially.
Can you talk a little bit about why you would have to do guardianship and what that entails?
Okay, so guardianship is, again, an adult who becomes incapacitated and cannot take care of themselves at all. And someone else has to be appointed as their legal guardian. There are two types of guardianship. There's guardian of the person and guardian of the estate. Guardian of the person is somebody appointed to take care of them like a parent. I've got to make sure there's shelter, food, medicine, they go to their doctors, all the things they need. Guardian of the estate takes care of all the money. They have to manage their finances, pay their bills, etc. Quite often the guardian is the same for both. They do both duties. The expensive part of it is not just the legal fees. When you file a guardianship, you have to pay legal fees, you have to pay court costs, but the court also appoints an ad litem attorney and a second attorney to look out for the interests of the person that's called the ward that needs the guardianship. We have to pay that attorney's legal fees. Quite often we have to pay accountants to come in and reconcile the finances to make sure they're right. We have to pay appraisals if there's assets involved. So the fees just keep adding on and on and on. And we have found that an average guardianship is $10,000 to $15,000.
And that's just to get started.
Just to get started.
Yeah, to start taking care of the other person.
And then once you have a guardianship in place, you have to report back to the court every single year. And so every year you do a report of well-being from the guardian of the person and of accounting from the guardian of the estate.
Oh, wow.
And so that's ongoing legal fees, ongoing accountant fees, quite often every single year.
Draining the estate.
It does. It
Yes.
drains the estate quickly.
And
I always say that really, unfortunately, we have to do them because they're necessary, but the only people that really win is the attorneys, because we get paid no matter what. So that's why I love putting documents in place to prevent that, so that my clients don't have to deal with that later.
so, and this is pretty obvious, I think, but what we had been talking previously about blended families. So what are some of the issues that you see that you might want to make people aware of prior to this being a necessary thing, you know, like when they're getting ready to do something? Because we see so many times people come in and the father's kids come in and want to represent him, and the mother's, and they don't want to be separated.
Yes.
The parents don't want to be separated, but they, you know, because of just how things work out, they want to take dad here and mom here. So talk a little bit about, if you are a person involved in a blended family and you're putting a will together, what are some of the things you need to be considering to take care of some of that as you age, so that your wishes are pretty explicit, so that that can't happen to you?
One of the things in my line of work, you hear the term estate planning,
Mm-hmm.
and I've never liked that term, because when people think of estate planning, they think of money.
Mm-hmm.
You know, your estate, what is your stuff? And so they don't think about family planning. And so that's one of the things we do. We put together what we call a family and money protection plan, because we're not just protecting your money and your assets, we're protecting your family. And we're protecting your family from itself and from other people. A blended family is a family fight waiting to happen, because you've got personalities from all different sides. You've got dad's kids, you've got mom's kids. Sometimes we have mom and dad's kids together. It's just a powder keg waiting to explode. And people say, well, our family gets along. Well, yeah, they get along when things are calm. It's when things aren't calm, when mom becomes incapacitated, when dad dies, when something disrupts the calmness of the family, everything can go south very quickly. And so what I focus a lot on my family planning is, how do we put a plan together to keep families from fighting? How do we put a plan together that if child number 6 over here isn't happy about it, they can't cause problems for everybody else? And that really is why you need a detailed plan. And people come in and say, well, my life is simple. Well, yeah, maybe it is, but probably it's not. Because if you have, especially, I get these all the time. Well, we have a real simple estate, but she has kids and I have kids. Well, that just made it unsimple. Because if you want to do it right, you want a comprehensive plan that says all the things you want, so that nobody else can come in and say, well, this is what mom wanted, this is what dad wants. And if there's nothing in the documents that say otherwise, that opens the door for them to fight.
And then that would be another legal battle.
A huge legal battle.
And it could tie, okay.
Yeah, and so, whenever there's a family fight, again, I always tell people, who wins in a family fight? The lawyers. Because the lawyers get paid no matter what. And you don't want that. I did a lot of contested guardianships, contested probates from families that were fighting. And I said, if you ever want to find out if your family's dysfunctional, have somebody die and leave some money behind. It comes out of the woodworks of how greed can take over and cause major, major problems in a family. I've had situations where brothers would never ever talk to each other ever again because they're fighting over dad's money. It's absolutely ridiculous. But if dad would have put a plan in place that was detailed and said, this is exactly what happens if I become sick, this is exactly what happens when I die, they don't have anything to argue about.
Great. So for a little further on that, we had talked about the care. That's what we see a lot from the senior living industry is, mom and dad, they want to take them separate places. So would that all be in the trust? Would that be a trust situation or?
Yes, it can be. Well, all the documents kind of go together. Mm-hmm. And that's why I'll get people that'll call me and say, hey, I just need you to do me a power of attorney. I said, well, I'll do that, but you need more than a power of attorney.
Right.
You can't just rely on one document to take care of everything. We want all of your documents to coincide together so that they can be used whenever needed. And so a trust is part of that. We do complete plans. And so, for instance, a trust plan would include a trust, and it would include all the living documents we talked about earlier. It would include a special will called a pour-over will. And our trusts come in binders about 3 inches thick because we want to make sure we have everything in there that we need if the time comes. I would say that I live on the philosophy that we pray for the best and we plan for the worst.
So let me ask this. I know this is going to be the next question on people's mind. What does it cost what is the average cost for setting up a family trust and some of these other documentations that you're recommending? Do you have like a group document plan? You have to pay individually by each thing? How do you recommend that?
Most estate planning and elder law attorneys, and again, you want to make sure that you get an expert do this. Mm-hmm. If somebody came to me to do their bankruptcy, I would send them to a bankruptcy attorney. If people call me about a divorce, I send them to a family law attorney. You want to make sure that you get somebody that knows what they're doing in this area. Most elder law estate planning attorneys try to charge flat fees for their plans because I used to hate billing my clients and my clients hated getting billed. And you don't want this unexpected amount. So typically we put together flat fee packages. The reality is in this line of work, you get what you pay for. And so if you want a good plan, you're going to pay for it. And you better be prepared for that. And a lot of people get sticker shock because they're saying, oh my gosh, I had no idea it would be that much. Well, you can get it cheap, but if you get it cheap, you're going to pay for that because it's not going to be a good plan. The plan is only as good as it's written. And so typically our plans, they can run from my simplest, what I call my college student protection plan. I do documents for kids as they turn 18 and they're going off to college. That's $750 for 9 or 10 documents. It's a simple will, simple power of attorney, medical power of attorney, etc. It goes from that all the way up to $8,000, $10,000, $15,000, depending on what people need.
Which is kind of a drop in the bucket compared to guardianship fees or what was the other one that people argue over?
The probate fees.
The probate fees,
Mm-hmm.
yes.
So I'll give you an example of how that ties in. Our typical single trust plan. So a trust plan and all the documents for a single person is $3,750. The cost of a probate starts at $5,500. So when I get people that come in and they'll say, well, I just want you to do me a will. Well, I can do you a will. And a will package for a single person that's not the simplest is about $1,250. But then when you pass away, your kids are going to have to probate it. And today's rate is $5,500 a probate. So now you're looking at $5,500 plus $1,250. I think that's a little bit more than $3,750. And now you've avoided all that.
Right.
So it usually works out in that same area, is that when you really look at the total cost, yes, it's more expensive to set up a good plan at the beginning, but when you look over what it's going to save the family over time, not just in money, but in heartache and stress and anxiety, it's worth every penny of it.
Yes. Well, is there anything else I think you've covered this beautifully and answered all of my questions. Is there anything else that you'd like to share with people about yourself, your law firm, or any words of wisdom?
Again, I would just say that you want to make sure that if you do this, do it right, and be ready to spend a little bit more money to get it done properly. Don't go cheap in this area of law. Sometimes I've told people that have come into me, they brought me documents that they did themselves, because now the big thing is the internet, you can do it yourself, or they had another attorney do it that didn't know what they were doing. I look at it and I'm thinking, I wish you would have just not done anything at all, because you would have saved the money that you spent on this, because now you've caused a bigger mess than if you wouldn't have done anything. So either, I can tell people, either don't do anything at all and we'll clean up the mess when we need to, or do it right and make sure that you get it all in place.
Well, Fred, thank you so much. I know I've learned a lot today, and if people are interested in talking with you, learning more about, or have other questions that maybe I failed to ask you today, how would they contact you?
Our firm is open to free consultations. I talk to people all the time, and I'm a resource to facilities and communities like yours. You can give my phone number out to anybody you want. I give my emails out to anybody. All they need to call is our office, and they'll be more than happy to set either a call up with me or somebody else if we can help them in any way. We're available as a resource. We're a little bit different law firm in that we are a faith-based law firm, and our philosophy is that God's going to bring us the clients He wants us to have, and our job is to give back. And we give back by things like this, trying to educate people on what they need to do and trying to help people make the best decisions for their families.
Great. Well, would you just give us the name of your firm, your name again, and the telephone number they can contact you if they're interested in learning more?
Okay, I'm Fred Haiman, and our firm is Haiman Hogue. My email address is fred@haimanhogue.com. That's HAIMANHOGUE.com. Or we're on the internet and we've got a website. All you have to look up is Haiman Hogue and you'll be able to find us.
Great. Thank you so much for your time today, Fred, and I look forward to meeting with you again.
Thank you, Don. Appreciate you having me on.